Radio Al Ansar podcast.
On with the show for this evening, an interesting topic. It's all about trademarks and patents, and we have the expert on the line with us all the way from Johannesburg. His name is Mohamed Jameel Hamid. He's a lawyer by profession, specializing in trademarks and patents. And with that, I say Assalamu alaikum and welcome to Mohamed Jameel.
Wa alaikum salam wa rahmatullah. Jazakallah for having me on the show.
Thanks for joining us this evening, Mohamed Jameel. I believe you are the expert when it comes to patents and trademarks, and we're going to explore what is the difference between a trademark and a patent a bit later on in the program. But as an introduction, tell us a little bit about yourself. You are an attorney or a lawyer by profession. What got you into that profession, and tell us a little bit about your younger days.
I wasn't always a trademark attorney for the start of my profession. I was a business consultant, and I was a director of a company within a public entity. I did my law degree prior to being a business consultant, and after having children, decided that I needed something a little bit more desk-bound, and so I decided to go into law practice. So I'm actually an attorney specializing in trademarks. Our firm does patents. I'm not a patent expert. I, of course, understand patents, and I can comment somewhat on it. I work for Adams & Adams. I'm a partner at Adams & Adams. We're Africa's largest IP firm, and we have 23 associate offices throughout Africa, and we have operations in South Africa. Our headquarters, where I'm based, is actually in Pretoria. We had offices in Sandton, and then we have Durban, and we have Cape Town as well. I got into trademarks because the firm I did my articles at specialized in intellectual property, and intellectual property covers all spheres where rights emanate from the intelligence or the intellect of a person. So that could be in the form of copyright, where you write a book or you write a song, or where you provide an image or you draw an image of something. And it also extends then to patents, which would generally cover agricultural and technological innovations, and this extends to medicines or new technologies and so forth. And trademarks, in which I specialize, covers specifically that territory where you would develop a brand which is indicative of where the goods or the products originate from. And of course, as we know, brands have a value in the market because we automatically can leverage that brand. So in my younger days, when I worked as a consultant, of course, I interacted with many brands. I was in the space of building materials and procurement and that type of thing. And when I traveled overseas, it's very clear that brands such as in the industry I was, you had Versace, and you had products such as this in the building industry, and they'd leveraged fashion brands across very different industries, and this was very fascinating. And today, alhamdulillah, I'm a practitioner in trademarks, and we do work throughout Africa and across the world.
Very interesting. Mohamed Jameel, if I can start by broadly defining what is the difference between a trademark and a patent? And I know you touched on it just now, but a clear definition of what would differentiate a trademark from a patent.
All right. So a trademark would be any distinctive symbol, word, phrase, design, or even a combination thereof. It even extends to a smell, or even an instrumental or a musical notation, so a sound essentially that will help you identify a product. So to put that in terms of an example, if we look at the Mercedes-Benz symbol, and with the three arrows, that is typically a symbol that would identify where that product originates from. So we look at that symbol, no matter what vehicle it is, whether we've seen the vehicle before or not, we will now know because of that symbol that product originates from Mercedes-Benz. A patent, on the other hand, is where you develop a new technology or an agricultural means of doing something. So typically we find this in the field of medicine, where you now discover or through research develop a new way of, let's say, you cure the common cold. And because you have spent a lot of money developing that technology, you will then acquire a right which you will register as a patent. And whilst you hold that patent, and that patent when you will disclose the information, you will disclose how you develop the technology, and you will disclose exactly how to make that drug. So it's in the public domain, but you are given a right over those, over that goods, over that technology, over that method and that medicine that you manufacture for a certain duration of time. And the rationale behind a patent is that what you want is you don't want to discourage somebody from investing in research and developing a product. Because if I've invested millions of rands and I develop a cure for cancer, and suddenly everybody else can then take my product and reverse engineer it and suddenly go into competition with me, that would disincentivize the development of new technologies. So the primary difference between a patent and a trademark is as follows. A trademark is merely a sign, something we utilize to indicate that the product originates from a specific company or proprietor. A patent, on the other hand, is a type of technology or new method of doing something to obtain a specific result, and I want to actually obtain exclusivity in that method. So the one's a brand and the other one's more technology or method-based.
Coming to trademarks, I think the ones that we all know well would be things like Coca-Cola, Pepsi, some of the banks, I would think, in this country, Nedbank, First National. Those would be things that have got trademarks. But when it comes to patents, and generally we talk about the big pharmaceutical companies and patents, and I know you said patents are not exactly your field, but trademarks are. But just to touch on that, if you go to a country like India, for example, and you have certain medicines that are the trademark, but you'll find lots and lots of generics out there or copies. Would patents differ from country to country? And then on the same token, what about trademarks?
Well, generally, most countries in the world are party to international conventions that regulate much of the intellectual property landscape. And the reason for that is, of course, you don't, if we don't respect somebody else's rights, so when I say we, if we in South Africa, for instance, do not respect the rights granted via patent in, let's say, the United States of America, then there's going to be no onus on them to respect our rights. So out of mutual or for mutual benefit, most countries in the world will be a party to a convention. So we would find that the rights that you would obtain in South Africa would largely be respected in America and vice versa. Now, when we talk to generics, that's actually not a breach of a patent. A generic is typically once the rights in the patent, which is granted for a limited period, once it expires. So let's take a product, let's say Roaccutane, which is a product that's commonly used to treat a variety of skin conditions. If that patent expires, then only will you find that other pharmaceutical companies will start to produce that as a generic. So a generic is not a violation of a patent. It's actually an exception to a patent because the patent has expired. Now, with trademarks, operates somewhat differently. Trademarks are jurisdictional, so you've got to make sure if you have a trademark that you register it in each jurisdiction. So if we have a trademark in South Africa and we've registered Al Ansar for broadcasting services in South Africa, it's not registered in India or Pakistan for that matter, then somebody else can open up an Al Ansar over there and they can, a radio station, and they can name it Al Ansar. So trademarks are protected jurisdictionally. It's also the case with patents, but we tend to find with patents that people will normally file that patent worldwide. There are conventions which allow you to file and then to use that application to simultaneously or within a period of 6 months file all over the world. So patents are generally protected quite well. With trademarks, proprietors don't often see the benefit in, why should I file a trademark for Al Ansar in Pakistan or India or Canada for that matter, because we'll never go there. So these are the differences between them. But patents are certainly something that do require protection. It does incentivize technological progress. Trademarks, on the other hand, are more to do with a reputation and being able to market your product and to show consumers that, this product has a history of quality behind it. So these are the fundamental differences in how we operate between trademarks and patents throughout the world.
Okay, great. Interesting. Would a trademark hold for any kind of product. What I'm driving at is, if I have a trademark, for example, that I've registered for example, for a brand of clothing, which is the industry I come from, would somebody that's in the food industry, to use a silly example, be precluded from using that particular name because it's been registered as a trademark for the clothing industry?
No, not necessarily. So if one looks at, let's take an example of the clothing industry and perhaps something not in food. Let's look at petroleum. If you look at Puma, which is a very well-known clothing brand,
yes,
and yet we also have Puma filling stations. So the test that the law generally uses is whether the consumer would be deceived or confused into thinking that the goods originate from the same party. Okay. If the products are sufficiently dissimilar, consumers will not be confused, and then the trademarks registry will permit a registration for even a very similar or identical mark, provided the goods are very far apart.
Okay. Because, a company like Mercedes-Benz that we spoke about earlier, they also have brands of clothing under the Mercedes banner, and I would be similarly for a lot of the other big car brands, for example, because of the fact that people would want to associate with the quality of that particular brand.
True. In most instances, the bigger brands, including car manufacturers and so forth, will even hold trademark registrations for clothing, so that have a special registration for clothing. But over and above that, there is some protection in South Africa within our Trademarks Act, which protects well-known trademarks. So, for instance, Rolls-Royce is a very well-known brand, and if somebody decided to produce bicycles and call it Rolls-Royce or anything similar, Rolls-Royce would be able to take advantage of the well-known stature of their mark and then stop the other party from using it. So there is some protection. I must mention that there's boundaries with that protection, but it is quite extensive. But the threshold for proving your mark is well known is quite high. You need to prove that amongst consumers, there's a very reasonable or a not negligible amount of people that would associate your brand or know your brand. And as a result, if somebody else uses it, even for goods that are not related, it could cause consumers to be deceived or confused into thinking it originates from the proprietor of the well-known brand. And the rationale is sound, because, if I or you were at a marketplace and we saw a product, and if it had a Mercedes-Benz logo on it, whether it be an item of clothing or even if it was a perfume, we would think that it's legitimately originating from Mercedes-Benz, and automatically, the quality and all the reputation of Mercedes-Benz, we would feel is inherent in the product we're going to purchase. And that, of course, is deceptive, because you wouldn't pay the same price for something that is made by a third party with no name or no brand or no history as you would for typically a Mercedes perfume or a Ferrari perfume, as the instance may be.
Okay. Talking about geographical trademark patent registration, the one that comes to mind immediately is Woolworths, because Woolworths South Africa, as much as they have a presence in Australia, they do not own Woolworths Australia. Woolworths Australia is a standalone company but doesn't belong to Woolworths South Africa. So one can confuse the two. If you're going to Australia and you see a Woolworths and you immediately link it with Woolworths South Africa, but it's a completely separate entity and a separate company. And although Woolworths South Africa are in Australia, they trade under a different name. So you could have two Woolworths in two countries and owned by two completely separate entities with no links to each other.
Absolutely. And I'm sure that must happen in a variety of instances. But there's no commercial prejudice to either of the entities, and I'd explain. If I'm in Woolworths South Africa, I can only trade in South Africa because I'm based here. So if somebody goes to Australia and sees Woolworths there and confuses it and buys there, there's no commercial prejudice to me in South Africa, because I could never have sold my product in Australia because I'm not based there. So yes, there is room for confusion between countries or territories, but there's no commercial prejudice to either of the proprietors. So there's actually no reason to govern that. Of course, if you are now trading all over the world and you happen to have somebody that's now in a country and people are unaware and they think that brand is associated with you, you do have some recourse. You get for instance, by way of example, if you've got McDonald's that's all over the world, and somebody opens up, a McDonald's or a lookalike business in a country where McDonald's isn't, even though McDonald's is not registered there, they can go to that country, and most trademark laws will permit them, as a well-known mark, to stop that person from using the mark. But that's a specialized case where somebody is deliberately trying to usurp the reputation of a very well-known trademark. But in your example, it's two different proprietors. They operating in good faith, they're independent from each other. And I don't think there's any commercial prejudice in that instance if somebody, makes the mistake of thinking they're related.
How can businesses protect their trademarks?
Well, first and foremost, the most important thing is to apply for and register your trademark. The process is not very difficult, but it can be lengthy. It's from 18 to 24 months. You'd file or lodge your trademark. A trademark attorney would assist you with that. And to explain the process, what happens is after you file your trademark, the trademark registry in South Africa, which is CIPC, they will then examine the mark. In other words, they will consider the mark. They will look at what other marks on the register, whether your mark is already registered or perhaps there's something very similar on the register. Then they will refuse your mark, or they may permit registration, but they'll then have certain conditions. They'll tell you need to notify X, Y, and Z that you're registering your trademark. And assuming you make it through the process of examination and then your mark is accepted, the next step is the mark will be published. It's published in the Trademarks Journal. The reason for publication is a way of notifying the public that this mark is now being accepted and this party is likely to obtain rights in respect of that mark. If the mark is published and there are no objections or what we call oppositions, then the mark will proceed to registration. Once the registration certificate is issued, you will then have exclusive rights to use that mark for the goods or services that you've registered the mark. And you can then renew that registration every 10 years into perpetuity. So it's a valuable right. And of course, the most important part of this right is that it can pass on successively. So even if you sell the business, that right can go with that business and that brand can continue to operate indefinitely.
Okay, you touched on a point of 10 years. So does that mean that if you don't re-register or renew that registration after 10 years, it can fall away and somebody else could take over that brand or label or trademark?
Absolutely. There is a provision within the Act that allows you, some leeway. So if you do not register or renew your trademark registration, rather, you've got a period within which you can then, make submissions to CIPC and the registry and request that they reinstate your mark. But yes, strictly speaking, if you fail and you do not, with good reason, you fail to renew your mark, that right will fall away and a third party then can register that similar mark.
Okay, let's talk about some of the benefits of registering a trademark.
Well, the most important benefit of registering a trademark is, of course, that you now can enforce that right of exclusivity. So you can stop somebody else from using your mark. And of course, that's very important because competition is such that, if you build a reputation in your product, people will want to leverage your reputation, cause confusion, because then they can garner some benefit from your mark and they can sell their product. So if you register your mark, the most important benefit is that you acquire exclusive rights within the jurisdiction of the country that you're registering. So, for example, if it's South Africa, you'll get exclusive rights within the whole of South Africa. The next benefit, of course, is that, as business progresses and the brand itself develops some value, it's appearing, if you look at large conglomerates and international businesses, they actually have a line that indicates a value for their trademark. So Coca-Cola or any other big brand will actually, or Apple for that matter, would quantify to some extent, and it would have an asset value for that entity. So, of course, you want to protect that, and that's the purpose of registration. The other benefits of having registration is that the enforcement of your rights is particularly easier than if you didn't register it. So if I didn't register and I traded as Al Ansar for broadcasting, but I never registered my trademark, if somebody else went into the same business and also had a radio station and also named it Al Ansar or something very similar, I would be able to take them to court on account of the user rights I have. In other words, unregistered, but I've been using it and people associate the mark with me. The difficulty is I would have to then prove that reputation. I'd have to give extensive affidavits and I'd have to show that people associate broadcasting with me. And that could be quite tedious and, of course, very expensive from a legal perspective. If I have a registered trademark, all I need to do is appear before a court and say, here's my registration certificate. I have statutory rights in this trademark, and that person is using it for the very same services that my mark covers. And so of course, it's less costly and much easier to enforce the rights.
Can you use a trademark without registering it?
Absolutely. I mean, in general, people would often use a trademark without registering it. So, you have a business and you name it something and you continue using it. And like I said, you develop common law rights or user rights in the mark. And when you're ready, you can register it. Of course, as I just hinted earlier, it's very difficult, or more difficult, I should say, to enforce your rights if you haven't registered it.
Take a silly example, and you spoke about McDonald's earlier. If I have, or if a Scottish gentleman has the surname McDonald and he wants to open a corner cafe and call it McDonald's because of his surname, doesn't he have an entitlement to do that?
Well, if somebody wants to use their name, our law provides for that, but you have to use then your full name. So, typically, let's take an example. So if it's McDonald's and your surname is McDonald, and you Smith James McDonald, then you can use your full name, but you will not just be able to use McDonald's on its own. And of course, what would be the rationale for starting off a food business using your surname when there's already a well-known brand in the market utilizing it? It can only be incentivized by wanting to leverage that brand. So our law would prevent that. You can use your name. Of course, if you have always been using your name, as is the case in some countries where people have always been using their surname, let's say McDonald, and they were in a food business or something close to related, then in that instance, they can continue using it in conjunction with McDonald's that may have registered their well-known trademark. So they can then coexist, but there has to be a legitimate reason for that. You have to show that, you've been using it. It's not in bad faith, it's in good faith and that type of thing. But I'd be very surprised if a corporate such as McDonald's will permit somebody else to come newly into the market and utilize the same name, because I can only think that it's incentivized, by improper motive.
Okay. I think it boils down to what is the intention there, and obviously there would be some leverage in terms of trying to benefit off the back of an established brand. But by the same token, if my surname is McDonald and I'm using my surname, then to an extent, I think I should be entitled to, and probably had that surname in the family for generations before the actual McDonald's were started.
Yeah, I mean, I understand the reason why somebody would want to use their surname, but I think if there's already an existing business in the market, it would be unfair. I mean, if we take our own businesses, I mean, many of our predecessors named the businesses after the family's names. I'll give you an example. You've got Applewires in Johannesburg, which is a very popular takeout or restaurant. And if somebody else, because he's got the same surname, and I mean, he's legitimately got that surname, his family's always had that surname. But if he wants to open up a business and use the same surname, I think it would be unfair, because he's now leveraging somebody else's goodwill and hard work over the years. And the question would be, why call it Applewires? You can call it anything else. So, I mean, look, of all the legal systems in the world, I think the Islamic legal system, more so than any other, recognizes intention. In the Malamalu bin Niyat, every deed is judged by its intention. So I think the intention is important. I can only think that intention would be to deliberately cause people to think that you're associated with another successful business, which in itself I think is dishonest. So I tend to believe that shouldn't be allowed.
Okay. Talking about international registration of trademarks, one particular incident comes to mind, and it was a few years ago where a well-known clothing company here in Durban had registered the name Gap, GAP. Now, during the days of apartheid and sanctions, many of these international chain stores didn't trade in South Africa. And post-apartheid, a lot of them did come back, well-known ones recently, Zara, H&M. But the name, the Gap label was registered in South Africa by this well-known company. And I think it actually went to court much later on when Gap International, extremely well-known throughout the world, took them to task for using the label here. And if I'm not mistaken, the local company actually won the case based on the fact that they had registered this label in South Africa many, many years ago during the days of apartheid. Are you familiar with that case? Any comments?
Yeah, no, absolutely. I am familiar with it. I mean, it's happened in more than one instance. There's also a similar case where Edgar's owned the mark Victoria's Secret. And during apartheid, what happened was there was a lot of proprietors, a lot of businesses who didn't trade in South Africa. And, you know, their marks may be famous now and people all over the world may know it now. But at the time when the marks were registered, Gap, for that matter, or Victoria's Secret, the courts found was not famous at that time. People didn't know it. So when this proprietor in South Africa registered the mark, even though he saw it there and he brought it and he decided he's going to use it here, he wasn't leveraging off anybody's goodwill because it was not famous at the time. So in many of those cases, the courts found that perhaps in today's time, the marks are famous and you can argue that they are famous, but at the time of registration, when that South African proprietor sought to register the mark, it was not well known, it was not famous. And so his registration he was entitled to register it. It was not in contravention of anybody's rights, and that's why it succeeded.
Okay, and the other one that comes to mind more recently is the one with Polo and Ralph Lauren, and Polo South Africa and Polo International. And I think on the different brands, Polo South Africa and Polo International, the horse or the rider of the horse on the pony is facing in a different direction. So that's another case that comes to mind.
Absolutely, and I mean also a similar situation, and there are other. If one looks at the court cases and so forth, there were other contractual arrangements, and I think Polo South Africa is certainly entitled to trade in South Africa. They've built an extensive reputation, and I think they're entitled to that trademark, and they do trade in South Africa, and they retain their trademark rights. There was a recent court battle regarding that, and they were successful, and I think the court found correctly.
Okay. Can generic or descriptive terms be registered as a trademark?
As a general rule, no. So when we talk about generic or descriptive terms, for example, if I want to register the mark shiny white for toothpaste, generally the registry would not permit something of that sort, because the registry will say, well, everybody wants to say the result of using their toothpaste is going to result in shiny white teeth. So that would be descriptive or generic terms. However, if one has used something which might come off as generic extensively, then you have built a reputation in it, and then you would typically be entitled to have rights in it. I mean, if one thinks of We Buy Cars, it says to what the business does, it's descriptive to that extent, but it's so widely used. When I say or somebody mentions We Buy Cars, you don't think of the phrase as descriptive. You think of it as pointing to a business that does a particular thing and it's acquired a reputation. So as a rule of thumb, no, descriptive terms or generic terms are not entitled to be registered in terms of our law, but where you've used it extensively and you can prove that it's become distinctive of your business, then you will certainly be entitled to registration.
How does a trademark infringement occur?
So a trademark infringement occurs when a person has registered his trademark. So it's not a case where somebody has used the mark, but it's not yet registered. That would be a case of common law rights, where you have an actual registration. So you've applied at the CIPC, and you've now got a trademark registration certificate. If somebody uses a mark that is visually similar or phonetically similar or conceptually similar, then that would constitute trademark infringement. So to give you perhaps some examples, because not all of these terms are easily understandable. Of course, visually means that it looks the same. So if I have a trademark and it has it's the word sword, and somebody else has a similar trademark for the exact goods, and his mark is SVORD, then visually those marks are very similar. Phonetically, when they are similar, we mean they sound similar. So I have a trademark, and my trademark is polo, and you decide to register a trademark and your mark is Rolo with an R. But they phonetically sound similar. People can get confused, and that's a case also where trademark infringement can occur. Conceptually similar is slightly different. This is when the marks that are competing with each other bring to mind the very same concept or idea. And I suppose the easiest way to explain this is if I have a trademark for clothing and my trademark is spider, so it's the word spider, and somebody else registers the figure of a spider, so the logo of a spider, depiction of a spider, he chooses to register that as his trademark, inevitably the consumer is going to think they're related. They're going to think, oh, well, this is just, spider's got our logo. And so if you have a registered trademark and somebody else has a mark that's visually, phonetically, or conceptually similar, he would be infringing your rights, provided that he's using his mark for goods or services that are covered by your registration. Perhaps I should just speak to what the impact of infringement is. If somebody is found guilty of trademark infringement, then a court would generally give injunctive relief, which is typically an interdict to say, well, you've got to stop this. You've got to take it off the shelves. Our courts and our Act also provides for a royalty. So there's an assumption that you would have had experienced damages if somebody copied your mark and use it for similar goods. In other words, he got sales where you should have got those sales. Our court will typically then assess and say you've got to provide a royalty on the value of goods you sold to the person that suffered the trademark infringement.
Mohamed Jameel, the policing of trademarks, I mean, our police force is stretched so widely. Where would the onus lie in terms of policing these trademarks? Because are the companies that actually register these trademarks expected to kind of police their own trademarks, or would the normal police force kind of look for this? And perhaps they wouldn't know what to look for in many a case.
Absolutely. I mean, that's a very good question. Generally, trademark infringement, and when it comes to trademark disputes, it's considered to be civil disputes in most cases. So typically, the proprietor of the trademark's got to police the trademark himself, and of course, in a case of infringement, he needs to then enforce the trademark. There are instances where trademarks are to some extent policed by the authorities, not by the South African police per se, but by customs officials. So this would typically happen where you have a trademark and then you do a recordal with the Customs and Excise Department, and then they know to be on the watch for counterfeit goods. Counterfeit goods are goods, of course, that are produced illegally using the identical trademark, for similar identical goods, creating the impression that it's the original. That's, of course, a criminal offense. So in that instance, the authorities will then, they'll attach those goods, and the proprietor can then ask for those goods to be destroyed, or the authorities themselves will have it destroyed, and there can be criminal sanctions against somebody that has appropriated a third party's legitimate trademark. Okay,
I mean the famous kind of symbol that comes to mind is the Nike swoosh, where it's worldwide known. It's a registered trademark. But then again, as you said, counterfeit goods, one can walk the streets of certain cities of the world, or even in our own South Africa, and sometimes these counterfeit goods are being sold quite openly. Very, very difficult to police in terms of getting to the source of who imported those goods or where they were originally bought from. Many times bought and sold by cash changing hands. Must be very, very difficult to police these type of trademarks.
Absolutely. I think there's a lot of effort, and a lot of the businesses that are subject to this type of counterfeiting is, of course, the smaller consumer goods, because they as you say, is cash changing hands, and often the consumers are sometimes aware that the product might be counterfeit, but they of course just want to enjoy the benefit of having the goods and saying that I have in this instance Nike or Adidas or whatever it might be. But we find that the corporate businesses, they're aware, of course, of these practices. They have their own investigators in the market. They, of course, have law firms such as ours. And in our case, we have an extensive anti-counterfeiting department. We have internal investigators, and we have a number of attorneys that are dedicated towards this practice. And we very commonly and often we do raids. And as you've pointed out, there are certain, parts of cities or towns, or even towns or cities themselves, that we know that counterfeit goods are easily available, and we'll specifically conduct raids in conjunction with the proprietors. So the policing does happen. Unfortunately, it's not something that can be completely stemmed out immediately, but we find that over time, the proprietors are very successful because it becomes very expensive. Of course, if somebody's a counterfeiter and you then have thousands or hundreds of thousands or millions of rands worth of goods destroyed, it of course has an impact for that business, as illicit as that business might be, and that often does stop it for some time. So there is success, and there is certainly many measures, and especially now with Customs and Excise participating and the ability to record these things with them, it is depleting access to these type of goods.
We've got a WhatsApp message, and the listener wants to know why it takes so long to get a brand registered.
Well, I suppose the main difficulty is, of course, that we have thousands of trademark applications, and we, of course, have limited resources. The problem is something that we find through many registries in Africa. I think it's more pronounced. But with the development of more technology or better technology, we're finding that this is being stemmed. In South Africa, for instance, much of the applications are now done electronically, whereas previously you would file a paper application and would have to find its way to a physical file. That physical file had to find its way to an examiner, and then it would have to move from department to department. That's now being alleviated with an online system, and we've seen at least a saving of about 6 months over the last, I would say, 18 months or so. So it's 6 months shorter now than it was previously, and I expect that will improve in time to come, inshallah.
I suppose the short answer to that is also get a good trademark lawyer.
Absolutely.
We got a few seconds left, so I'm going to kind of end by asking you what would be the cost involved with registering a trademark, and then we'd call it a night for after that.
So generally, the cost of registering a trademark, this is now including applying for the trademark and then attending to the publication and attending to the registration, would cost you between 8,000 and 10,000 rand, but that's over a period of 2 years. So initial upfront costs would be 5,000 to 6,000 rand, depending on what type of advice you need and so forth. I'm giving more a comprehensive cost here so that one can budget for that. Uh-huh. And then subsequently, towards the end of the period, you'll pay the remaining 3,000 to 4,000 rand to finalize the registration. So in a nutshell, about 10,000 rand for one trademark.
And would that include the lawyer's fees as well?
Absolutely. It's fully inclusive, all the costs in general, all the advice, and also helping you to determine, what you should register for, what should be covered, because the specification of goods is phenomenally important, and that's where the trademark attorney comes into play. He needs to understand what you're registering for. He needs to understand what the law provides, because there's certain overlaps our law provides for. So, for example, if you've got a registration for clothing, you can even enforce it against somebody who has cosmetics with the same name. And if the trademark attorney understands that, he will assist you to draft a specification that will give you the broadest cover.
So it's not as easy as going onto the CIPC website and just registering a trademark?
No, absolutely not. In fact, quite a bit of my local practice is from people who have filed trademarks using CIPC and then ran into difficulties and eventually had to spend additional money to have us come on record to assist them. So to your point earlier, yeah, it does matter what type of trademark attorney, or that you have a good trademark attorney at the least. Okay, excellent. Mohamed Jameel, it's been wonderful chatting to you. Thanks for joining us this evening and giving us some insight into trademarks. I've certainly learned a lot. And inshallah, when you're in Durban, please give us a look up and we'll get you into the Al Ansar studios. Absolutely. I'll be very glad to chat to you again. Jazakallah for the opportunity. And assalamu alaikum wa rahmatullah. Wa alaikum assalam wa rahmatullahi wa barakatuh. And that's it for another Business Matters program. And I'll see you again, inshallah, in 2 weeks' time on another Business Matters program. So with that, wassalamu alaikum wa rahmatullahi wa barakatuh.